Florentine history. And so we kind of took one section of the National Historic Preservation Act regulations that had kind of been ignored, which says that loss of historic use can be an adverse effect. And in their report to Congress, the Advisory Council picked up on that theme and essentially said, yeah, you know, I think that's a good idea that we should enforce our own regulation that requires us to account for the loss of historic use as well as the potential damage to architectural and artistic features. And so where the Advisory Council, to its credit, did not back down, but did not have an opportunity to finish its comment. The Postal Service just wrote, after proposing this ludicrous, you know, fox in the chicken coop notion that it itself would administer the covenant. They just said, we're done. And that in itself is unlawful under the National Historic Preservation Act. They could be honest and say, we know we are producing an adverse effect in terminating the use and in restricting public access and in not guaranteeing the integrity of this building over reasonably foreseeable time. But they didn't do that. They said, we're done with you now. We don't even have to answer to that. So that's essentially the National Historic Preservation Act claim. And notice that there's not an approval there. There's an obligation to comment and listen. And that's how these cases are won, when the government agency just bullheadedly refuses to listen. As I say, there's a very strong comparison to where the post office is today and where the Federal Power Commission and Corps of Engineers were back before Dave Sive, who was probably the founder of modern environmental law, challenged that in the Scenic Hudson case and a proposal to build a pump storage facility along the scenic part of the Hudson up in upstate New York. And the Second Circuit said, as a citizen group, they can bring this claim, and more importantly, the Corps of Engineers has to consider environmental values, which they've refused to do. Well, the NEPA claim, doing an environmental impact statement, which is very important primarily because the environmental impact statement, aside from requiring a documentation and an assessment of the environmental impact of one's proposed action, requires the examination of alternatives. And, you know, bullheaded agencies generally don't like the sunshine of publicly comparing what they want to do with alternatives. And in this case, there was a double offense. The Postal Service decided not only that it didn't need an environmental impact statement because this wouldn't have an adverse effect on the environment. The Postal Service essentially declared themselves exempt from NEPA totally, which is an offense, and that's one of our claims. But worse than that, they didn't tell anyone they did that until they had to defend against the temporary restraining order that Judge Alsop issued in November. And they had to bring in papers to show that they thought they had complied with the law. And we learned then that a year and a half ago, doing exactly what the courts say agencies are not supposed to do, just shuffling paper between one office and another, they signed a paper saying that this is totally exempt from the National Environmental Policy Act. Yeah, and they did it in secret. You know, the Postal Service takes great pride in saying that they're part of the Constitution, and the basic question that we're asking in this case is, they're part of the Constitution, but they don't yet believe they're part of the government, that they have to act like a government agency. And so those are the two claims that we presented. I think Brian and I and the trust in our office and the city were all pretty conservative. We didn't look to pick a fight. really up until late September, when that shocking thing came out last September that, well, we'll be the covenant holder, and we still had an opportunity to respond to that. We were hoping that between pressure from Congress, the Advisory Council, and as Zach and I have always said, when this controversy first arose, when I talked to Zach the first time, I said, don't they know this is Berkeley? And Zach said, yeah, that's what the staff's been saying all day. So you would have thought that all those factors might have convinced them, maybe we want to just forget this one for a while or do it differently. Well, we then learned, again, keeping this all very secretly, but through a postal worker, I think we heard the rumor that the building was actually under contract. And so when that was fairly, couldn't be ignored anymore, we then brought the lawsuit to enjoin it because, again, they wouldn't reveal who the buyer was, they wouldn't reveal the contract. They still have refused to release the contract. They've still refused to release the building stability report that Hudson McDonald prepared when it was in contract and which it delivered to the Postal Service according to their contract. So it's sitting in the Postal Service files, but Post Office treats that as confidential information. So we had to go to court, and Judge Alsop immediately issued the TRO because we had alleged that the sale could close at any moment, and once the sale closed, then it's no longer a federal building and all our federal protections are gone. And so then the Postal Service came in to oppose the preliminary injunction that we were going to have heard. Initially the judge was going to hear it the following Monday. I thought, that's sweet, gives the government 2 days to respond, I'll take those odds. But the government said, you know, we'll agree to do nothing until late December if we can have more time, which was a fair request. I will say this, the lawyers involved on this from the government side, from what we've seen so far, are, as we found in the Freeway case, they are decent principled lawyers. So we're not facing a lot of the game playing that one sees in a lot of litigation. So, in fact, if the lawyers could educate the client, we might get somewhere on this. So we agreed to let that the TRO could stay in effect until, I think, the 17th of January. And lo and behold, on the 5th of December, Hudson McDonald pulled out of the contract. We don't know why that happened, but I don't think it's our lawsuit that made that happen. I think they got the seismic report or the structural report and thought, you know, maybe we bid too much for this building, and maybe they thought, you know, this is just going to be a headache. So they had the ability to withdraw, and they did withdraw. And so then they argued, well, now the case is moot. We should just dismiss the case and go home. And that's where the case is now. Brian just filed his papers in opposition today. I just picked those up when I got back from Forest Hill this afternoon. We filed our opposition last week. And the case would be moot, as our papers concede, if the Postal Service said, without saying it out loud, my God, you're right. We are going to set aside our decision to sell this building. We're going to set aside our decision that this is categorically exempt. We are going to reopen our discussions with the Advisory Council, but, you know, before we do that, we're going to prepare an environmental impact statement the way NEPA requires. That would make the case moot. But that's not what they've done. They haven't proposed to do any of that. What they have said is, we kind of just don't know what we're doing here. That's literally what their declaration said. And, you know, the hearing was kind of, the one hearing we've had in front of the judge was the day of the big storm on December 11th. It was by emergency lighting. I was quoted in the Daily Journal as saying it was like conducting oral argument on a submarine. But the judge, when the Postal Service, you know, argued it was moot, and the judge said, well, you know, what are your plans? And the U.S. Attorney made this similar statement that they later put into a one-paragraph declaration. And the judge said, don't give me that stuff. I was in government. I know foolishness when I'm hearing it. If you'll tell me that you're not going to sell this building for 4 or 5 years, I might think that this case is moot. But nonetheless, I'll give you a chance to file papers, and that's where we are now, and that will be heard on March 19th. The judge is a hard-working guy. If you want to come to that hearing, you got to be there at 8 o'clock, and as we learned, hurricane force winds and a darkened courtroom, we're not going to keep him from conducting the hearing. And then after that, I feel very confident that we will get past that. Then we'll wait for the full record to be prepared, and we'll then brief the case on the merits, because so far our briefing has been focused principally on this question of mootness. It's hard to predict. If we use the Stamford Post Office timetable, which I think is going to be a little longer than what we should expect here, I think we'd expect this case to be argued on the merits sometime in the fall. So, I guess before concluding, and you obviously have questions. The other thing that makes this very interesting is that the buyer is Hudson McDonald. Well, I think a lot of you probably know Chris Hudson.
Yeah.
No. He built the Trader Joe's, right?
Yeah, they did Trader Joe's. I'll use the personal pronoun, the first name, Chris. He just stepped down as chair of the board of the Public Schools Fund. He and his wife are very active in Berkeley High athletics. His one daughter graduated last year, is now at Yale playing soccer at Yale as a freshman. His other child is now a freshman. So, Chris is dialed into the community. And, in a sensible world, since he's the one person that the post office has found who seems to be interested in buying the building, their firm, the Postal Service, and the city would sit down and try to work out something. And the something could be one of two things that I think would be satisfactory to my client, the city council. And if you don't like this, you got to let them know, of course. But I think either one of these would be good resolutions. The first would be that the post office retains ownership of the building, continues and actually improves the service up front to where it looked like maybe 2 or 3 years ago, and then leases the rear. If you go to the Superior Court of Alameda County, downtown Oakland, if you're not in the county courthouse over near Lake Merritt, you're in the U.S. Post Office building on the 2nd floor. So the Postal Service knows how to lease its space for other use. A passport office used to have a separate office there. There are a lot of uses that could take place in the back of that building without doing a lot of major work. The other alternative would be to sell the building, but with a truly long-term leaseback to keep the post office in front. And the city council, the city's comments proposed 50 years. And we did that. We advised the council that that was a good alternative because in Dallas, Texas, the federal building, which was a magnificent, huge city block building that had customs and FBI and everyone in it. The building was sold and made into luxury condominiums, which made sense in the context of that land use in downtown Dallas. But the magnificent first floor looks exactly as it always has, as a true gem of a post office. So a 50-year leaseback would not be a bad outcome. I'd rather wish they would have the good sense to know that they've got a really good property there, that they say they don't have a lot of business downtown. Well, like it or not, we're getting a lot more residents here downtown, and downtown Berkeley is, going to become the next Hayes Valley, as I tell my former compatriots on Hay Street, and they're foolish, and it's just plainly ridiculous from their own mission to sell that building. Anyway, so those are some thoughts, and I'm sorry I've taken so long, but I wanted to try to paint a picture of the setting as well as just the narrow legal questions.
Well,